Hello and welcome to Crime and Justice. I'm Donna Rotunno. Today, we're going to be talking about the Gaudreau brothers, the brothers who were killed by a drunk driver in New Jersey. We will also be talking about the lack of DNA evidence in the Nancy Guthrie case and what does that mean for the investigation moving forward. Also, we'll talk about why I am in New York today and not in my home studio in Chicago. We're here listening to what's happening with the Clinton depositions regarding Jeffrey Epstein. So a lot to get to today. Thanks for joining me. Let me bring in my first guest, Patrick Fagan. Patrick, thank you for joining me.
Donna, this is awesome. Thank you for having me. I'm super excited.
So glad to be here with you. And we could spend the whole half an hour talking about sports, but we won't because we'll get into our criminal justice circumstances here. But I love to have you. Tell the audience a little bit about yourself and how you got into criminal defense work.
26 years I've been doing this. Passed the bar exam in 2001, July of 2001. Been working like a dog ever since.
Totally.
It started with you, pretty close starting with you the first 4 years. We worked in a small firm together, branched out on my own, and I've been fighting cases. I was just telling Peter, I picked up a case in Champaign County yesterday. It's my 30th county in Illinois that I've been in. Successfully defended somewhere over 100 felony criminal cases at the trial division. So it's my life's work. I've been doing it my whole life, and it's been great.
And all those sporting events you go to on the weekends with your kids, which is awesome.
Yeah, well, it's all those sporting events now.
That's right. Well, I'm so happy to have you. Speaking of sporting events, let's talk about hockey and our wonderful USA gold medal winners on the men's and women's side. But let's specifically talk about Johnny Gaudreau and his brother who were killed by a drunk driver in New Jersey. This case got so much attention because of just the utter sheer sadness that went along with it. Johnny and his brother were riding their bikes along a road for their sister's wedding, and it was the day before the wedding, and they were out together. The whole family was celebrating, and they get hit by a driver in a truck who admitted to having drinks at the time of the arrest, 5 or 6 drinks, he said. And then at the time, the blood alcohol level came back to 0.087, which is above the legal limit in New Jersey. Now, the lawyer's contention is they had an expert come in. The expert has done testing on that blood. They had only tested the plasma portion of the blood. And now in testing the full blood sample, the blood sample comes back to 0.75, which puts it below the legal limit for the blood alcohol content. So although that sounds really scientific, and it is a little bit, let's talk about how that affects a criminal case when it comes to a DUI case that involves a reckless homicide or a death versus just an accident that would be awfully sad. So let's talk about the differences there a little bit.
Yeah, absolutely. First of all, just echoing your thoughts on the case. I remember when I first heard about it too. It's just a horrific set of circumstances. Almost too difficult to imagine. I think it happened too. I think they were going to. I think wasn't their sister getting married the next night.
Yes.
So it's just unfathomable. I think it definitely involves a different set of circumstances when you're dealing with a death case, right? If it was just your standard run-of-the-mill misdemeanor DUI, this thing would probably be worked out, right? For a reckless driving in one court date. There's a lot of other factors here, and simply because the chemical test runs less than the proposed legal limit doesn't necessarily mean that they weren't, under the influence or impaired. Furthermore, I think important in this case is the fact that it's a death case, and one of the big factors I think in this case is going to be causation. I haven't heard what the defense arguments are yet, but I think not only do you have to prove that he was impaired, but you have to prove that impairment was a proximate cause of the death. And then you start to be asking real questions about what was the contributing negligence or the contributing recklessness of the alleged victims in this case.
Well, I know they're going to talk about the bad driving. I think that there was a witness, so there was another vehicle on the road that was driving slower because of the two brothers on the bikes. And then the truck that was driven by the person charged in this case, the truck was driving recklessly and sort of trying to avoid this other car. So I think there's going to be an element of bad driving as well. But in terms of the DUI aspect, it's interesting because most states, and New Jersey's one of them, have statutes that allow for you to charge DUIs, and then in combination with the death, obviously a reckless homicide or a manslaughter, you can charge those cases. But there's usually some type of a factor that sort of gives you an idea of the level of impairment. And if a state has a number that they consider to be an impairment, right? Most states are either 0.10 or 0.08, and they lowered that to 0.08 in a lot of jurisdictions many years ago. When you look at that number, and you can argue as the defense, yes, he had alcohol in his system, but it wasn't so much to impair him in this circumstance, right? If the state of New Jersey says this is how we determine whether you're under the influence of alcohol, there's also, there's other charges, because if somebody doesn't blow, right, or doesn't provide blood samples, you can charge someone with DUI. But when you charge them with the DUI, you have these signs of impairment. But now that you actually have the blood, I think the argument for the defense, of course, is going to be he doesn't reach that marker. So yes, it's unfortunate that this was an accident and the accident caused death, but is it this more heightened situation? So, I mean, it's an interesting case for lawyers to debate, because I think there's actually good arguments on the defense side, regardless of how awfully sad this is.
Yeah, no, I mean, anytime the legal limits or the blood test, or if it was a breathalyzer test, comes under the legal limit, that's obviously a good sign for the defense.
Yeah.
I mean, you and I go back, trying misdemeanor DUI cases. If it came in under the legal limit, that case was over.
Right.
I mean, now, but of course, that doesn't necessarily, it's not dispositive of the case. You can still prove a DUI even if the person comes under the legal limit 0.08 through other factors. I'm sure there's field sobriety tests. There's obviously the way they were driving. There's admissions. I know in this particular case, the driver made admissions to both drinking and some reckless driving. So there's other ways you can prove the case. And I'm certain in this case that the chemical test, the blood test coming under the legal limit will not be dispositive of this case. And then, to be a long story short, I don't see this motion that the defense has filed within the last couple of days getting off the ground and the matter being dismissed on their motion.
Well, even if it is dismissed, right? Even if the judge says, you know what, I'm going to toss the indictment, because what the defense is contending is the grand jury would not have come back with an indictment but for this information that he was above the legal limit. So, I mean, what's the remedy? Okay, the case gets dismissed and they go re-indict him. So
yeah, they would get another indictment by tomorrow.
Yeah, and 100%. So, what are you really winning? And that would be the conversation you and I would have with the client. We would say, well, what are you winning? You're winning nothing. And just the sentiment around this case, the totality of the circumstances here. I mean, this guy should have been an Olympic gold medalist. And now, the family has to go to court and worry about, the punishment for the person who caused their death. It's just really, it's an awful set of circumstances to be on the defense side and have to come up with an argument that combats all that.
Its timing is very unique. I would agree with you. You see on Sunday morning them parading around his children, his jersey, and just this epic moment, and now you have this legal wrangling just days later. It's unfortunate timing for the defense, to say the least. It
is, and I probably would have either held off on it or tried to do it before. Right. And remember, Johnny's wife was pregnant. Meredith was pregnant at the time of his death, and the baby was born several months later. So, I mean, this is just, just keep adding. When you think of something that can't be worse, there's, one more factor here that just makes it so much worse. I mean, you add the components of the baby due and the wedding happening the next day. And not only do you as parents lose one son, but you lose two. I mean, it's just, it goes from bad to worse every time you talk about it. In terms of the driver's statements to the police after the crash, right? He admits, I had 5 or 6 drinks. That's damaging.
Yes. And
as a defense attorney, there's really not a lot of ways that you're going to get that statement tossed out unless it was made in a circumstance where the police are asking him questions before reading his Miranda rights. But if they just come up to the car and he says, I had 5 or 6 drinks, that statement's coming in.
Yeah, I mean, and as a defense attorney, you try to explain it away, you try to minimize it, but as they've said, as judges have looked me in the eye and told me several times, your words have significant legal impact, and that's why you haggle like crazy to try to get statements like that from being admitted, because if they're admitted, it is very problematic for whoever the fact finder is, whether it's a judge or a jury, no doubt.
Yeah, and no matter, and I'll put this out as a disclaimer and a disclosure, no matter how sad these cases are and no matter how horrifying it is, the defense and the defendant still have the right to due process, and the law should still apply. So if the law was not followed, if there is a reason that a case should be dismissed, then it should be, regardless of the circumstances, because that has to take precedence. I mean, we see it in Luigi Mangione, right? I mean, I'm sure most people think, except his crazy supporters, but most people think Luigi Mangione deserves the death penalty, which he's not going to get, because frankly, the judges, I think, made the right decision based on the law. We may not like it, but if you look at the law was pretty clear in that situation. And even the judge said, this is a decision made with, I think the word she used was it's torturous or turmoil or whatever word she used. It was fraught with difficulty, but, that's their job. Sometimes you have to make the tough calls.
Yeah, as far as that case, I'm in the same boat as you. The evidence appears overwhelming. There's still a long way to go between here and there. Here being, where we sit right now, and there being when they give the case to the jury after a trial. But based on everything I've heard, the evidence seems overwhelming. I think, frankly, the government's biggest concern right now, or I think probably one of the major concern is during the jury selection process, can we keep one wackadoo from sneaking through and essentially cutting him loose on the case based on their own creation of justifiable homicide because of whatever because he works for profit insurance company. I honestly think that's probably the biggest concern of the government going into that case.
100%. I talked about it with Will Kane on his show about this OJ effect, right? Like, do you have to worry about the OJ effect of the jury, where they just kind of disregard the evidence and they make decisions based on other things, which could happen in a case like this in New Jersey with this drunk driver, because the sentiment and the emotional side of this is so strong that you could just get jurors that are like, I'm convicting this guy regardless of what they say because of how awful and terrible this case is.
Yeah, no doubt. And in my experience, and I'll say this, when you have a murder case or a dead body case, I think the beyond a reasonable doubt standard is often forgotten, frankly. Yeah. And I think if the jurors are sitting there and if they think that this person did it, if they really believe in their heart of hearts that this person did it, the beyond a reasonable doubt stuff is no, I'm convicting this guy.
Yeah.
And I think that's something that as defense attorneys you really have to battle through, and I think that will be a factor in that case for sure, no doubt.
And when you look at this case again, and we talk about the alcohol component, right? If the alcohol component is not there, right? If this is just a regular person that was going to the grocery store that didn't have a drop of alcohol and was driving down the road and either didn't see them or got cut off by a car and caused a crash that killed them, that doesn't necessarily become a criminal case.
No, right.
It just becomes a tragedy that somebody has to live with the rest of their life. So, this is what they are trying to do as the defense, of course, is to remove any of the obstacles that make it a circumstance that rise to the level of this criminal nature here.
Yeah, DUI death cases, are tough. They really are, because obviously you have this situation in which you have the horrible situation. You have people dead. Generally, you have a prosecutor's office that's under some pressure to get a pretty stiff sentence. Yet, as you know, it lacks the dark heart malice that's so often a part of criminal cases in which you're asking for a significant amount of time, right?
Yes.
I think we've advanced far enough as a society to where we recognize that a DUI isn't just a accident now. You're making a conscious choice, whether it's before you started drinking or after you started drinking, to get behind the wheel of a car. But it does lack a certain malice that's present in so many criminal cases that you and I have dealt with over the years, that there is an uneasy feeling sometimes when, you're asking for 18, 20, 25 years for what's ultimately an accident. So
Yeah,
I think that's a factor.
I think the maximum here is like 60 or 70 or so. It's a huge number.
Right.
But to your point, I think that the prosecutors had offered like 30 or 35. And I think the judge has talked to the parties and said, you should really try to work this out. I think the defense did present a counteroffer to the state. So we'll see what happens. And the argument that the state uses every time, because you're right, about nobody gets in their car, whether they've been drinking or not, thinking I'm going to go out and kill someone, right? Like that's not the way these cases usually come down. And so this is a circumstance where, this happens. It's awful. It's sad. And the prosecutors say that car, the minute you had one drink, you knew that car was a weapon, right? That's the argument they always make. They turn the car into the weapon, and you got behind the wheel of that car, which is basically like having a loaded gun in your hand. And that's the argument that they always make to try to resonate with the jury. And, we'll see.
No, and I both get that argument. I do, but I also disagree with it for the reasons I said before. And if we could talk for hours about this, and then ultimately kind of come to some resolution if we were the judges to think what this thing would be worth if he was ultimately convicted, the number would be less than 35 for me.
Agree.
Be more than one probably.
Yeah. Well, in a lot of jurisdictions, I think if you have multiple, and I don't know exactly what the factors are that make it that huge number, but in most places, if you have multiple deaths, I think it's like 6 to 30 or 6 to 60, maybe 6 to 60 in some jurisdictions. So, obviously, most people don't get the maximum if they don't have prior background. So, like you said, that number is high.
That's the other thing you keep forgetting, though, too. There's two bodies,
Yes.
It's not just one.
And, again, there's no value that you can place on those lives and what they would have contributed to society. And no matter what that court does, they're never coming home. And no matter what the punishment is, no matter how this guy feels that he can get out of this, if there's a technicality, you still have to live with the fact that you killed two people, that not only two people in general, but two people with immense opportunity and immense talent and people that had a lot to give back to the world. So this is just, and children without their father. And we could go on and on and on about how awful it is. So do you think we'll most likely see a plea here?
It all depends on how motivated the parties are to get it done, right? What's going to be how motivated is the state to give them something reasonable, right? Yeah. As long as they're pushed on by victims, the press, and they're offering numbers like 35, it's not going to get worked out, right? But any case, not just a case like this, but any case, a negotiation is a number of things. How, from the defense perspective, how beatable is the case? What's the maximum penalty if I lose? What's the minimum penalty? What's the realistic penalty? You put that all into a stew and you make a determination. Yeah, I on this case, just on the face of it, I don't know a lot about the case. Again, there's a long way from here to there. I would think this is the type of case that could potentially be worked out if they come to some reasonable.
Yeah, I think so too. It has to be reasonable, because if it's not reasonable, you might as well go to trial, right? If you have no other choice but to roll the dice, you roll them. So
yeah, I always say if you're offering me the maximum, you're not offering me a choice.
That's right. That's absolutely right. That's absolutely right. Peter Valentin. Peter, how are you?
Well, thanks for having me, Donna.
So
good to meet you, Patrick.
You guys are great. I'm so happy to have you both today. Peter, tell me a little bit about what you do in New Haven.
Oh, thanks. So I'm the chair of the Forensic Science Department at the University of New Haven, one of the largest forensic science programs in the country. I have an unusual background in not only a forensic scientist, but I was actually a detective with the Connecticut State Police prior to becoming an academic here at the university. So I kind of cover things from beginning to end, if you will.
That's an amazing perspective to have, because I think it really, I was a prosecutor before I was a defense attorney. I think it gives a perspective that's different. I've had family in law enforcement, and I think seeing things from more than one side is extremely beneficial in these cases.
It does. And then the work that I do now as a reconstructionist and as a person who evaluates cases, being able to follow it from the 911 calls, or, when, in this case, when the family calls, all the way through to the forensic lab results, you really do get to see where cases come together and sometimes where cases fall apart.
Yeah, that is so true. And speaking of, cases needing to come together, Nancy Guthrie is one of them. And this has now gone on to, what are we on, day 20 something, 25, 26? No, more than that, 29. This is really sad that we just do not know more, have more. And, I get it. Law enforcement doesn't have to tell the public anything. But this is one of those cases that is being talked about, whether they tell us things or not. And there just hasn't been much movement. Talk to me where we are with the DNA, how the DNA has been handled up to this point. Is there hope that this IgG technology that came through in Koberger could potentially help us here? Walk me through what's been going on so far.
So the challenge with using investigative genetic genealogy, as great of a tool as it is that we don't know, or at least we don't know publicly, whether or not we have any DNA that we can say with any degree of certainty belongs to the perpetrator.
Right.
Right. We have discarded gloves, and everybody talked about it last week, gloves that were found 2 miles away from Ms. Guthrie's home. Now, in any other investigation, something found 2 miles away would never even be considered as relevant physical evidence. But in this case, it was. Now, I don't know why that was. Perhaps there was something about it that really caught the investigators' attention. We've come to find out that, more than 16 pairs of gloves or 16 gloves were found in, first of all, that's poor crime scene management, but yes. That's a story. That's a different story. But there was something about these gloves that caught the investigators' attention, and they were sent to be tested. But there's nothing to say that connects back to the scene itself. So even if you did investigative genetic genealogy, how do you know that information that you develop connects somebody to the Guthrie missing persons case, right? Or let's just say it's a missing persons case still. Let's be optimistic about this. What you need is a profile that you can say for sure was a person inside the home, ideally from a biological fluid, which is probably not what you have here, because that certainly would have been prioritized and dealt with by now. But here's the difference with the Koberger case, right? You had the DNA profile that was taken off the knife sheath.
Right.
Now that knife sheath was clearly brought to the scene. It correlates with the weapon that was used, and it connects Koberger back to the scene,
and
right?
It was
indirectly.
It was left at the scene. It wasn't left
exactly.
2 miles away from the scene, right?
Right. So you have all now, mind you, these are all inferences that we're drawing, but they're so easy to draw. Right? You have this item that wasn't there before. You have this DNA profile that you're able to get from it. It connects back to his father. The father has a son, and the son's located 20 minutes away from the crime scene. So these leaps that we're making logically are so small that we get right back to where we need to be. Here, we can't do that. We don't have that DNA profile. We don't have, or at least, we don't know publicly that there's that DNA profile that we can say for certain is from inside that house and belongs to the perpetrator. Now, what we have heard is that they've collected DNA and they've tried to eliminate some of those unknown DNA profiles by getting buccal swabs from, people who have been inside the home, family, workers, friends. The problem there is you can never really close that door. Right. You can never say for sure that we have gotten known samples to account for every unknown DNA profile. And why? Because DNA is so easily transferred now, because the testing is so sensitive, that I could shake hands with Patrick and I could take Patrick's DNA to a place that Patrick has never been to before.
Right.
And so we would never know to get Patrick's known DNA because Patrick never had a reason to be where I transferred his DNA to. Right. So we're trying to close a door that really can't be closed here. And that's what makes this a lot more difficult than it was in the past.
And I think the only hope in a case like this is you hope that it potentially points you in a direction, which doesn't mean that's the person who committed the crime, but maybe it gives you some lead, which they don't even seem to have a lot of those. And even if you're talking about people who have access to the house or had access, whose DNA should have been there, does that necessarily mean that those people weren't involved unless you're able to say, okay, they had alibis or they were here, or so it doesn't really help include or exclude, frankly.
No, and really, the way that I would look at this investigatively is that I would like to find the same unknown DNA profile in two
Yes.
disconnected places. Because now I can't say we've eliminated coincidence, but we've certainly made it hard to explain how your DNA is on a glove found 2 miles away, for instance, and your DNA is found in the living room or on the hose outside of the house.
Yeah, or
And
if Nancy's DNA was on the glove they found 2 miles away, then that's a
yes.
different story.
Oh, now if that were true, now if we had Ms. Guthrie's DNA on an item outside of the house and there was another unknown profile found on that, that item is immediately the most probative item of evidence in this case, bar none.
Sure.
I'm feel very comfortable saying that they don't have that yet
Right.
because that would immediately become the most important item they have.
And we would obviously know that if that was the case, I think, at this point. So now that we know that the sheriff's office sent those black gloves that we both, I never thought anything was coming from those either, but they sent those black gloves down to Florida, and now, they didn't send them to Quantico, and then they had the CODIS, nothing came through in CODIS. Now that they've done that, now that we have really not heard whether or not they're getting anything from IGG, are there any other options left when it comes to DNA for items that they've already collected?
Well, it really depends on how many items they collected. Now, this is where we get back to how did they consider the scene when they first had possession of it? And this is where, you know, the first misstep you make is the one that sometimes dooms your case to going cold, or sometimes, in other situations to becoming a wrongful conviction. And the analogy that I'll use in a situation like this is that, when people get lost and they make that first wrong turn, they don't realize they've made a wrong turn.
Right.
They keep driving, and at some point later, they realize they don't know where they are, right? So, not understanding what this case was about at the very beginning, you don't recognize that. There's still so many investigative leads that need to be followed up on, and those eventually dry up. But by the time they dry up and you realize, oh my goodness, we've got nothing left to do, we're days, weeks into this, and now it's very hard to change course because all the opportunities you had to go in that other direction are gone.
Yeah.
Whatever evidence you could have seized isn't available to you anymore. And so the challenge is with cases like this is to entertain multiple, what we'll say scientifically, hypotheses, right? Multiple scenarios at the same time, but not favoring any one of them. So in a situation like this, let's say, is this cartel related? Is this the home invasion? Is the family involved, right? Those are three scenarios right there. Is this a neighbor? There's four. You work all of those
Right.
with the same level of interest or the same level of scrutiny. And what will happen is the physical evidence and the investigative leads will support one, and the other three, four, five, six will eventually wither away for lack of information. That's how you're supposed to do this. But that kind of runs counter to what we think of, because we think of detectives as running on hunches. My gut tells me I should do this or that.
That's probably the
And
worst thing, right?
it really is.
Yeah.
I mean, hey, we all have them, and I'd be lying if I said I didn't have them myself. But you can't run on those to the exclusion of pursuing things objectively.
Right.
And if there's a fault here, it's did they push one version or one scenario too hard and leave other options behind and not consider them?
Yeah, and I would think that that's probably true, unless, they have been, we don't know, and they've come up with zero all across the board. And so I guess we just don't know. And then when we hear this term cold case, is this a cold case? I mean, obviously it means that there's nothing happening, there's no new information. At what point, I mean, there's still a lot of tips coming in here. At what point is something truly considered a cold case?
So it depends on who you consult with what defines a cold case. There's no investigative leads in 6 months and 3 weeks, or so, you can define some arbitrary, date or time period where there's no investigative activity. But what I'll say is that every time you keep adding to the reward, you're going to get new leads. And you could say that that keeps the case from getting cold. but how viable are these new leads that are coming in? So investigators are busy, but are they really investigating things that have potential value as far as this case is concerned? I don't know. Perhaps there's a tipping point where the amount of money is so high that the person who does know something, because clearly somebody knows something who isn't saying something, they finally do, offer that bit of information that breaks this thing open. This case isn't cold yet, but, finding that bit of relevant information from those thousands and thousands of leads that, really amount to nothing is just such arduous work. And there's no way to easily go through it and parse out which is good and which is bad. You all need trained eyes on all of them.
And Peter, if you're advising the FBI about what to do, what do you tell them to do next?
So this is one of those cases where, and they don't happen very often, where you want to prioritize the analysis of physical evidence. A lot of times, forensic evidence is really the lagging indicator of what you understand investigatively. You submit evidence and you're waiting weeks and months and maybe sometimes even years to get results. And by the time you get those results, they're confirming things you already knew or the things you've already developed. And in a case like this, you're actually waiting for the forensic evidence to tell you which way to go. And so this is maybe what even happened just within the last day or two, that a new group of investigators came to the house. And what I would suggest is that you go into that house with the best people in each discipline in forensics. Go into that house and scrutinize that house, looking for the trace evidence that must exist, or hopefully still exists. Because if people went into that home, and we believe they did, right, to take her from that house, there must be evidence of their presence in that home. Right. Where is it? What is that evidence? We need to find it. And now it's not going to be, because otherwise we would have found it, it's not going to be the obvious DNA profile somewhere. It's not going to be the obvious latent fingerprint. It's probably some of the things that we've probably not used as much, right? The hair, the fibers, the other kinds of trace evidence. But we've got to start cobbling together all the forensic evidence we have at our disposal to move this case forward, because otherwise it might not move forward.
And, Peter, this is obviously a high-profile case, given the fact that it has received the attention that it has, given the fact that Nancy is the daughter of Savannah Guthrie. So does that make it any different? People ask me all the time about cases I have that are in the news, and clients will say, oh, you're on a case that's more important than mine. No case is more important than any other. Somebody else decided to put a camera in my face. And so that's kind of how I feel about these cases that become quote unquote high profile. Like, yes, they're high profile for the world that knows about them, but does law enforcement really handle these things any differently than they would any other crime that comes across their desk?
Donna, the way that you described it is exactly what my experience was. Like, at the scene level, at the investigative level, we handle these cases exactly the same way. And I don't think any of us ever really understood why one case got attention and one didn't. Sometimes there were demographic issues. Sometimes it was a slow news day. We never really understood why one got attention and one didn't. But what I can say is that, when there is intense media scrutiny, a lot of times unforced errors occur.
Yes, because there's too much of a push, right? There's too much of a push to try to resolve, try to move quicker. Yeah.
Yep. And in every case I've looked at since, and I've watched it, from my perspective here in academia, as I try to teach the next generation of investigators and forensic scientists. The more scrutiny there is, the more pressure there is, the more unforced errors occur, and ultimately, the more challenging it makes that eventual prosecution.
Yeah, I got some really interesting questions on my social media today regarding DNA. And one of them I thought was very intuitive and interesting. And it came to me from someone on Instagram, and he asked about the sheriff's decision to send the DNA to Florida and not to send it to the FBI lab. And had he made a decision to not send it to Florida as he has said he has done, and they've used this lab for 30 years. Would that open up any scrutiny on past cases regarding that Florida lab? Would somebody come forward and say, well, why didn't you use the lab? Did you not trust the lab? And I thought that was an interesting question to ask rather than just say, why not send it to Virginia?
Yeah, that's an interesting question, but that lab has a great reputation in the forensic community, and a lot of agencies around the country use them in one capacity or another. And the same accrediting body that would accredit a governmental forensic laboratory would accredit them as well. So we're all meeting the same standards, whether we're public or private. So, that line of inquiry, if you will, would be easy to kind of, push back on. But, from a public perspective, I could see why that would come up.
For sure. Peter, thank you. Your expertise is so helpful in these cases. You really help me understand some of the things moving forward here, and we hope that they will continue to find information that will help lead to the discovery and or rescue of Nancy Guthrie. Thank you so much for your time. You've been great.
It's been my pleasure.
Thank you. All right, Patrick, I have one hard question left for you. As I said, I am in New York today because we've been following the testimony of Hillary Clinton and tomorrow Bill Clinton in the depositions regarding Jeffrey Epstein and his business dealings and his influence in politics. Tomorrow, Bill gets on the hot seat and has to answer questions. If you were asking questions in that deposition, what would you ask the former president?
Well, at the fear of being reductive, I would want to know everything.
Yes.
Obviously, my interpretation of the Epstein stuff is this is a guy that clearly did a pretty good job of ingratiating himself with normal society, normal high society, right? So at what point did the normal non-criminal contact end and the criminal contact in which you knew stuff or participated in stuff that you shouldn't have been participating in
or
began?
Gave him information?
Right. And obviously if you're one of the lawyers that's questioning him, you have access to a lot of information. Some of this stuff is going back to maybe the 80s, right? 90s. This is not something that happened last week. This is not something in which you have, digital footprint for like we would if this happened within the last, 6, 12, 18, 24 months. So I'm assuming they're armed with a lot of information, and I would want to lock him into some sort of answers on everything that I know. And I know that's kind of a reductive answer, but I think it's important to ask him about everything. That would be my position.
And, I have gotten the title over the years of the anti-Me Too lawyer and the lawyer that tried to take down Me Too. Do you think that this Epstein craze is the new hashtag Me Too?
Yeah, in a lot of ways, it is. It's all so ugly and disturbing, you
Yes.
know. I think it is. I think a lot of the Me Too might have gone a little too far, and maybe we're creating controversies where they weren't really there. Based on the information we're getting back on this, at least so far, it feels like there was. I have to admit, there's a lot more there than I thought there was going to be.
Well, and remember, we're talking about children, which is a whole different, people that don't have an ability to consent, which was much different than the Me Too cases, right? The Me Too cases, a lot of it came out of Hollywood, and a lot of it came out of, pay for play and quid pro quo situations, which are much different than what we're dealing with Epstein. But given the fact that it has gotten such bipartisan support and agreement here, I do think that what we're seeing is pretty mind-boggling, and a lot of the questions that have never been answered about Epstein will continue to swirl in the air, and we will spend time looking at all of these issues as we move forward. Patrick, you are awesome. I was a baby lawyer with you, and it's so fun to be doing this with you now.
Stuart Goldberg's office, 05, 06. I can't believe 20-something years has gone by.
Isn't it crazy? Well, it has been a pleasure to have you take the ride with me my entire career, and thank you so much for being here with me today. You're amazing.
Yeah, pleasure's been mine. Thank you. I'll come back anytime.
I'm Donna Rotunno. Thank you for joining me on another episode of Crime and Justice. Remember to send us your thoughts and your theories. We want to hear from you. And don't forget to subscribe on YouTube or anywhere you get your podcasts. See you next time.